And welcome back to Risky Times. I'm Stephen Karras. I'm joined today by Chris Kirkblythe from LBS Legal and Mike Chard of Web for Law. Limited on time, but I just want to move us now to the other key area of risk, which is money laundering legislation and regulations. Now, so really we're going from one area of the law which requires responsible limitation and accountability for the gathering of data, whereas now we're looking at another area of the law which requires really sort of like an open access, if you will, on a risk-based approach, as I believe it's called. In other words, we're now into the area where you're being required to make a judgment as to gather as much information as you feel is necessary to protect you against those clients who would be trying to perpetrate crimes with your assistance. Now, July of this year, the Serious Crime Bill was put forward, and this, among other things, was intended to believe, prevent the recurrence or the growing recurrence of what the regulator deems as professional enablers. In other words, those professionals, i.e. solicitors, who turn a blind eye when being instructed by clients who are instructing them on criminal matters which they're not aware of. In other words, this bill is designed to, I suppose, scare them into action, into making sure that they focus very clearly on their duty to gather such information as is necessary. Chris, what do you think about the Serious Crime Bill? Do you think that it's necessary? Do we need that?
I can't see any justification for it. I'm not aware of any empirical evidence which suggests that the legal profession is either deliberately complicit in the cleaning up of dirty money, or indeed negligently complicit, or this concept of deliberately averting your gaze. I deal with and advise many hundreds of solicitors and dozens of legal practices, and I just don't see this as a big issue. I don't think solicitors launder money. I think undoubtedly some dirty money passes through the client accounts of some solicitors, but I think their degree of complicity or recklessness in regard to that is very minimal nowadays.
One criticism brought against it already has been that it doesn't identify what would constitute a sufficient level of due diligence in order to mitigate the risks of being accused or allegations of being a professional enabler, because obviously solicitors don't want to meet that allegation. If we're talking about on a technical basis of not gathering sufficient information as being leaving you open to gathering, being a professional enabler, then I suppose it begs the question: how much information is appropriate? Especially when we've got data protection law that's come through to say, you have to be mindful of exactly how much information you gather. So, again, I think we find that solicitors are between rock and a hard place. And Chris, you just said you don't believe that solicitors are deliberately enabling criminals.
I think politicians profoundly misunderstand the mindset of the profession. I'm generalising, but to answer a question like this, you have to generalise. In general, solicitors are cautious, careful, risk-averse individuals. They are terrified of the money laundering regulations and the money laundering legislation. It is utterly draconian and almost impossible to comply with completely. And they're very acutely aware of it. And in fact, in my experience, the bigger problem is solicitors being excessive in this regard, slowing their businesses down too much, preventing transactions from running smoothly, creating unnecessary difficulties for clients, and of course, on a very wide scale, breaching legal professional privilege by making unnecessary reports to the criminal agencies concerned. So I just don't think the politicians have made any case whatsoever for increasing the regulatory burden upon the profession yet further.
Mike, what do you think?
Well, I think the situation is that there's two ways of thinking about the reduction in the number of reports. It could be that solicitors are...
Are you talking about the reports solicitors make to the authorities?
Well, is it that there's less reports being filed because lawyers are complicit in the fact that people are trying to launder money, or is it that in fact the lawyers are doing a good job and there's less reports being filed because criminals are thinking to themselves, we can't do the sort of things we used to be able to do because the lawyers are more aware. So is there a reduction in the reports because solicitors are being complicit, or is there be a reduction in reports because solicitors actually are doing the job that they were supposed to do? Right? And the honest answer is nobody knows. Right? But to make the assumption that because the number of reports have dropped off means that somehow lawyers are complicit in it, I don't really see how that logically follows on. And there isn't I don't think that the statistical information to back up what's being said.
What we do know from the statistics is that the frequency and level of serious crime is on the decline.
Yes.
Therefore, one would expect the number of reports to be on the decline as well.
And interestingly, also the NCA, the National Crime Agency, has announced that it will no longer process any disclosures for consent if there is no evidence of a suspicion. I think all too often, historically, solicitors have made disclosures to get consent on the basis that they just don't have sufficient information to make them feel comfortable to proceed. Now that again puts them in a difficult position because they're being told hold back on the reports that you make, but don't be a professional enabler. Don't turn a blind eye. So again, it's sort of damned if you do, damned if you don't. Interestingly, also on the 8th of September, the SRA have announced, of course, a new focus project which they've embarked on, and will be doing so until May of next year, visiting firms to test their systems for tackling money laundering are sufficiently robust. Again, this places an evidence, places a focus clearly on your systems of due diligence, sufficient data gathering. Now, we know in the Data Protection Act that one of the principles requires you to gather information which is not deemed as excessive. You should not gather excessive data in relation to amount. It should be appropriate. Then there's the question of sham litigation. We have a lot of firms that will carry out due diligence to the point where they're asking clients about their business affairs, their financial affairs, their income, based on a personal injury claim. It's got no basis, it's not relevant, but they're so worried about being targeted by criminals that they're taking these almost excessive steps to protect themselves. Now there is a real risk there, isn't there, that they're in breach of the Data Protection Act by gathering excessive data.
But I think yet again what you've highlighted is that we have some very serious and arguably draconian legislation which relates to money laundering and which requires solicitors to do all sorts of things. In a sane world, that would be sufficient. That would be regarded as sufficient. But that is not how things work in practice. How things work in practice is that we then have a regulatory body called the Solicitors Regulation Authority, who then add another layer of regulatory requirements onto the profession by saying, right, we are now going to come and look and see that your money laundering systems are sufficiently robust. If they're not, it's a criminal offence already. But the SRA are going to carry out these thematic visits, these random sort of audits, and they're going to look at your procedures and they're going to form a view as to whether or not they're robust enough. And if they don't think they are, they're going to take disciplinary action against you. Now, disciplinary action is a serious thing in itself. It's not a slap on the wrist. It's often catastrophic for law firms. It's often ruinous. It's always extremely worrying and lengthy and stressful and expensive. And the end result can often be that, the serious repercussions. There's the seizure by the state of your assets in terms of financial penalties. And, why would why would any sane country introduce a draconian criminal system of legislation and then seek to enforce it in an additional way by using a regulatory mechanism as well? It is regulation gone crazy.
And when you look at the fourth directive, the fourth money laundering directive, which is due to be implemented now in the first quarter of next year, the proposals, among other things, contain one to align the responsible gathering of data with the Data Protection Act. In other words, for example, setting limitation periods on how long a business can hold, a regulated business under the money laundering regulations can hold information. Now, for many solicitors, they will hold information, particularly wills, almost indefinitely.
Yes.
That in itself surely is going to create a problem, trying to sort of limit the amount of time that solicitors can feel justifiable for holding information. They may be able to feel.
It's even worse than that, because what's to be borne in mind is that if anything goes wrong and a claim is made against a solicitor, then unless they retain information, they can find themselves in a position where they cannot defend that claim. Right?
Absolutely. Yeah.
So, for example, when a solicitor acts on behalf of somebody to buy a property, and there's some issue associated with the purchase, which isn't apparent initially from the file, a latent defect, let's call it that, okay, which is the common term. But latent defect can mean all sorts of things. The fact of the matter is that the client has 15 years in effect to bring a claim. And I've actually seen this. A firm acted in the purchase of a property on behalf of a charity. At the time that they bought it, it's one of the few areas in the country where compulsory registration of title had not come into force. The lawyer dealing with it at the time thought that compulsory registration of title didn't affect this particular property. He was wrong. And the title wasn't registered. The charity then owned the property for 13 years and then decided to sell it. Okay? And when they put it on the market, they didn't go to the original solicitor, they went to a new solicitor, who then looked at the paperwork and said, but this title should have been registered. Right? So that was issue number one. Second issue was, actually when they looked at the plans, there was a bit of the garden at the bottom of this particular property, which they thought they owned, but in fact actually, for whatever reason, wasn't contained on the title. So the situation was that the charity then brought an action against, inverted comma, the solicitor who actually dealt with the purchase. But actually, the solicitor didn't exist anymore. In fact, what had happened was that particular firm had gone out of business 12 years before. It had been taken over by another firm of solicitors, who had in turn then been taken over by another firm of solicitors. And when it came to then this matter being identified, the action was brought not against the person who actually made the mistake to begin with, who was dead, but against the third firm in the row who had acquired liability because it was a successor practice. Okay? And even though they had nothing to do with the situation whatsoever, they ended up finding themselves caught by this claim. It cost £30,000 to put right. Okay, right. The file in question, detailing what had happened at the time, guess what? Had been destroyed. So nobody in that firm could say why something had happened,
So
what had happened.
Held on to
If
it.
they'd held on to it,
Yeah.
they might have had an explanation, a reason to actually prevent the liability. On the other hand, 15 years holding data on people for 15 years, they would turn around and say, well, hang about, why are you holding the data for 15 years? That's a breach of data protection.
And not only that, but obviously with cybercrime on the increase in the profession, the longer you hold that information, the greater the risk there is that it will be stolen. So in one sense, it's in your interest to destroy information that you don't need anymore at the risk of it being stolen by cyber criminals. But at the same time, there is an emphasis on needing to retain it to protect yourself from any sort of action in the future, being sued by clients, for example. And that's the problem, isn't it?
Yes, and I would say that it's not so much that solicitors are professional enablers I think they find themselves in situations where they don't appreciate the dangers involved. Perfect example, standard practice, somebody comes in and you've got to act for them and you want to verify that they are who they are, etc. So a solicitor will take a photocopy of the passport. Okay, fine. There we go. I've got a passport. I've got all this information. This is the individual, etc. If I'm a fraudster, I'm not that daft. What I'll do is I'll forge the passport. Okay, so I've got a piece of paper which looks as though it's the genuine article, but in fact it isn't. All right. Now, and the lawyer then says, "Oh well, this is all okay and it all looks all right," and lo and behold, it isn't. And again, I'll give you a specific example. There was an old lady, housebound, owned a property, and she had a carer who looked after her. And the carer stole the old lady's passport and forged, in conjunction with, inverted commas, her friends in Eastern Europe, that the information was all looked genuine. And then went to a firm of solicitors and said, "I'm so-and-so, etc., etc., etc. I own this property, yes, and here's my passport, here's my information," and it all looked genuine. Now, in fact, actually, if the solicitors had carried out electronic verification, yes, they would have discovered that the person who, inverted commas, owned the property was in actually age 75, yes, not 32.
Yeah.
But they didn't.
Yeah.
And it went all the way through, and they actually got a mortgage, and they did everything, etc., etc. It was all discovered because, in fact, what happens was that eventually a letter goes to the house, which saying, "Thank you very much, such and such has happened," or whatever it is. What do you think, right? And not the old lady, because in fact the old lady, because that's why she had a carer, right? Wasn't able to deal with things, but her daughter saw it by accident. And said to her mother, "Mum, I didn't know you were doing that." Mum says, "Oh, did I? Okay." Right? And guess what? It was too late, because what had happened was that the deal had been done, the money had been transferred. Yes, the carer was arrested. Yes, the carer went to jail, but that didn't help the solicitor, because the £150,000 that had been raised had gone to Eastern Europe, yes, and was never going to be got back again. Okay? So what it boils down to is merely looking at what looks like, yes, a genuine piece of documentation without further checks, okay, has its dangers. And we've all know about the various films, yes. We've heard of various practices where people steal the identities of somebody who is dead.
Okay, so in relation to gathering information about your client and the appropriate amount of time that you hold that information for, it's clear from what we've discussed that there is a conflict between the data protection legislation and the risk-based approach which is encouraged in order to tackle money laundering and other financial crime. So one of the things I come across often with solicitors is there's a lot of confusion about how often they should renew the information that they hold on existing clients. For example, some firms make it a point of, no matter what, they will renew it every 3 years, and they say that's what we must do. Others just say, well, whenever we get new instructions from an existing client, we repeat the due diligence process over again, which means that they're gathering more information and therefore risking a backlog of existing similar information. They're just gathering more information almost for the sake of it. And of course, they needn't do that because they're being encouraged to take the view that if you know your client enough, then you should feel comfortably about how much information you hold and how long you hold it for. As a best practice approach, they are encouraged to repeat the information gathering every 3 years, because obviously people's circumstances can change quite dramatically in a 3-year period. But again, it does beg the question with these new structures in place to reinforce these areas of risk, that it's not really clear as to how long or how far they should go in order to gather that information to protect themselves.
What you've just mentioned is another good example of regulatory creep, because there is no requirement in the primary legislation to carry out renewed due diligence
Yeah, absolutely.
every 3 years. I think there may be some guidance to that effect in the Law Society's practice note,
Yeah.
which was written as an advisory document.
Yeah, yeah,
But subsequently, that advisory document received approval from HM Treasury
yeah.
under the provisions of the primary legislation. Therefore, effectively, that advisory practice note has become a legal requirement, or certainly it would take a brave man to ignore it. So this 3-year requirement and lots of other requirements which are in that practice note have almost become regulatory requirements accidentally. Now, the correct answer to your question is that if you know your client, if you have carried out your due diligence properly on that client, you don't need to renew that ever.
Yeah, yeah, absolutely.
But not only do the Law Society and then the SRA gold plate these regulatory requirements, but then law firms do that themselves as well. So they will go even further than the Law Society practice note. And we end up in a ridiculous position which nobody ever intended. Certainly no executive or legislative body intended the money laundering regulations to work out on the ground in the way that they do actually work out. Nobody intended them to be so burdensome. But this is regulatory creep.
And it's a wonder, with all of this in mind, that the solicitors have any time to actually practice law and remain
Well, many of them
profitable.
will tell you they don't.
Why do they find the time to deal with all of this?
They don't.
On the regulation. Well, that's the problem, because it's all very well being so compliant and handling everything as you should and supposed to, regardless. But actually, the bottom line is they're running a business.
Yeah.
And if they don't make a profit, it doesn't matter how compliant they are, they'll go out of business.
Yeah.
So you know, there is this issue of if I follow all the rules and regulations, and by the way, by the time you've printed out the money laundering practice notes, of which we now, it's almost like an encyclopedia.
You don't have any paper
Yes.
left.
Quite frankly, I find it difficult, and we're specialists in this area. You know, once you've read through 50 pages of what can be quite mind-numbingly boring information, by the time you go to page 48, you're trying to remember what the hell it said on page 4. So it's very, very difficult. The key is they got to do the best they can, right? They got to do the best they can, and when actually, if ever, God forbid, the time arises, what they need to be able to demonstrate is that they did what was anybody would consider reasonable in the circumstances. And actually, bringing it full circle, that's exactly the way the Information Officer Commissioner is going to look at it. Right? If you can show that you've taken reasonable steps and you trained your staff, when things go wrong, that's your first line of defence. Okay?
Yeah. So it's all about mitigating the risk by
Yes.
demonstrating effective systems.
Yes.
Identifying them.
Yes.
And there is no competitive advantage in being the most compliant firm in the world. I cannot for the life of me understand why lawyers do not collaborate more in regard to the management of this compliance burden.
Yes.
There's no reason why 5 firms from the same town should not share resource in that respect, even if they compete aggressively in other areas.
Well, of course, we could talk all day. It feels like we have already. But I just would like to say, Chris from LBS Legal and Mike Chard from Web for Law, it's been a pleasure. Thank you for your time. And thank you at home for joining us on Risky Times this week. Hopefully you'll join us again for our next show. Until then, take care and we'll see you soon. Thank you. Bye.